Hello, I am Sara Niegowski. I am the Chief Communications and Outreach Officer with the Washington State Bar Association. I'm here with Washington State Bar Association Executive Director Terra Nevitt and Practice of Law Board member Craig Shank. We're going to talk about a pilot project to test entity regulation in Washington State and why the WSBA and the Practice of Law Board are proposing the test pilot to the Washington Supreme Court. First of all, for many of us, the concept of entity regulation is a new one. Can you tell us what that means? How are people currently allowed to offer legal services in Washington State? And how would this pilot test change that?
I think it's helpful to make sure that we all start with the same understanding about how regulation works in our state, which is that the Washington State Supreme Court has complete authority over who is authorized to practice law. And for pretty much all of our history, we have only licensed individuals to practice law. The vast majority of these licenses are for lawyers, although we do have several license types. And the point of the regulation is to ensure that Washington residents can rely on ethical, competent services when they are facing legal issues that impact their lives, their families, their safety, their livelihood. So what we're talking about here is a shift to licensing not just individuals, but to licensing entities. And what it might look like is regulating businesses or perhaps nonprofits who want to utilize legal technology or other people beyond lawyers to try to better serve their customers and their communities. And our proposal that we hope that the court will consider is to have a time-bound, carefully monitored test of what entity regulation would look like, because this is such a big shift from the way that we currently regulate the profession. We want to make sure that we can collect data and information to determine whether this should be a permanent approach to regulating the practice of law. So that is what entity regulation is, and that's how we hope to test it.
So it sounds like this is a significant shift in the history of how we have regulated legal services in this state. Why are we proposing this now?
Thank you, Sara. In Washington State, it would be difficult not to notice the impact of new technologies on the world around us, and in particular, the potential for technology and innovative business models to impact the delivery of legal services and the practice of law in ways that may be positive, negative, or both for consumers and for legal practitioners. Online companies and innovative business models are already delivering legal services to the public, and they'll undoubtedly expand in prevalence and sophistication in the coming years. Recognizing the profound implications of these changes and to better understand the opportunities and the threats presented by these emerging technologies in terms of safety, quality, and access to legal help for Washingtonians, we believe it's imperative to gather data to inform us about how to move forward and to help us inform the court.
And let me just add and underline some of what Craig said. As the Bar Association, we regulate the profession on behalf of the court. And in so doing, we are seeking to uphold the integrity of the profession and to safeguard Washingtonians. And with all these changes in technology and the delivery of legal services, it's imperative that we're paying attention to how it's impacting the profession and how it's impacting consumers. I think there are potential benefits there, and there are also potential risks, and we need to look closely at both of them.
My question then, we talked a little bit about the why now, and maybe what I'd like to know is the why. Have you had any experiences or stories about why you personally feel strongly about testing entity regulation in Washington?
Yeah, I've had the good fortune to have several decades of experience in the technology industry as a lawyer, and that means that I've spent several decades thinking about how to automate legal processes, how to gain efficiencies, and how to deliver better results using these technologies. But this issue came home for me 10 years ago when I was practicing in Europe I had a team in Paris who suggested to me that they get specific help for migrants, people who were in the immigration crisis in Europe at that time, and that we deliver that through a chatbot that would be enabled via mobile phones. The technologies were all there, and the legal support was all there to be able to deliver it. We came up with a solution. In delivering that solution to NGOs and offering it to them, we were informed they could not take it. It was not going to be able to be made available because the delivery would constitute providing legal services without a license, unauthorized practice of law. That I found very frustrating in the moment, but I had a chance to go out and learn a little bit more about it. I understood these indeed are the rules, and rules are made to be navigated here, and they're made to serve a specific purpose. And that then got me engaged just a few years later with the Practice of Law Board. And for the last several years, I've been working on different forms of pilot proposals for ways of entity regulation.
Interestingly, although my way of coming to it is a little bit different than Craig's, I think my reasons are similar. My professional background is in civil legal aid. So prior to coming to the bar, I was really focused on the access to justice gap, not only for low-income individuals, but even for the moderate income population. And for myself, when I've had legal needs, it's often been my instinct to try and handle it myself, making the presumption that it's going to be too expensive for me to hire an attorney to represent me. And, I've been thinking about access to justice issues for about 20 years. Other people have been thinking about them much, much longer than that. And sadly, it doesn't really feel like we've made a lot of progress, despite a lot of effort, despite a lot of resources, despite a lot of intention and goodwill in the legal profession. It just seems like our models aren't reaching everybody that they need to reach. And there are particularly pronounced gaps in rural areas, among certain populations. And so I see technology, again, technology and different business models as things that we need to be curious about, because they might be the innovations that we need to really make progress. And I think the data-driven approach is really important, because I don't think we just want to jump to the conclusion that technology or an innovative model is going to solve all of our problems. I think we need to be careful about unintended results, and we just need to be smart about it.
Thank you, Craig. Thank you, Tara. I think we understand a little bit of what this shift looks like and maybe what we're hoping to accomplish, but can you talk about the pilot test itself and what that would look like and what it would entail?
Well, of course, we won't know the specific details of the pilot unless and until we have an order from the court. However, at a high level, our vision is that we will be collecting applications from entities that would like to participate in the pilot, and that they will be proposing specific regulatory rules that they would like to test. Once we identify the entities that we'd like to work with, that have areas that we agree would be interesting to test, we will be seeking authorization from the Supreme Court to test those things. Then we'll be identifying what information we need to collect in order to effectively test and evaluate them. And then the goal is that after 2 years of collecting that data, reviewing that data, we will be well positioned to make a recommendation to the court with respect to this kind of regulatory reform. I want to ask Craig if you wouldn't mind talking a little bit more about what kinds of things we might be testing and how we will test them.
We anticipate that the data collection plans themselves will be part of the application for the pilot. And as the draft order presently notes, each applicant will be required to propose, first, a specific hypothesis relating to reforming one or more regulatory rules about the governing that would govern entities practicing law. Then we also anticipate that each applicant will be required to propose a study that will test that reform. That is a data model that will help demonstrate whether that has been achieved. And we are also going to ask them to collect specific data that will, over time, enable us to analyze whether some of the other objectives of the pilot have been achieved. Things like protecting the consumers of Washington. Things like ensuring that the services delivered expand access to justice and that they continue to deliver quality services.
So one of the Supreme Court's foundational concerns when licensing individuals to practice law is competence, safety, and consumer protection. With this proposed pilot test, how are you going to ensure those same kinds of safeguards for Washingtonians who seek legal help?
Well, competency and safety for the public is certainly at the center of all of our regulatory processes at the Bar Association. And this is something that we've considered carefully as we've developed this proposal. So first of all, part of the data-driven regulatory reform approach is to make sure that we have data to determine how the public is being served. To discover if there are any harms to the public and also to ensure that they are receiving quality legal services. So that's really built in to the model at a fundamental level. In addition to that, the proposal contemplates that we will be gathering data along the way and monitoring it closely. And finally, in the draft order that we will be proposing to the court, we've asked each applicant to identify a person who is authorized to practice law or is suitable in some other way to serve as the compliance officer. And that person will be accountable to ensure that the entity is complying with the court order that authorizes this exploration and all of the other ethical rules that apply. And I also want to emphasize that although the point of the pilot is to study variations in specific regulatory rules, the rules of professional conduct, all participants in the pilot will still need to adhere to all other laws, regulations, rules of professional conduct. The only exceptions will be those things that they are specifically authorized to test.
I think Terra covered that beautifully and very comprehensively. The fundamentals are that these entities will still be subject to all of the rules that are applicable to the practice of law and to people doing business in Washington, other than what the narrow exception is for the purposes of the pilot test. And they will have to have supervision that is appropriate to the task that they have decided on, and they will be subject to ongoing reporting and data for the court.
What about lawyers and other legal professionals? Will this pilot test impact their practices and the more traditional way legal services are being offered by firms?
As an integrated bar association, we not only serve the public, but we also serve the members of the profession. And the way that we reconcile those two responsibilities is that we serve the members so that they may serve the public. I believe that regulating entities would be a way to ensure that we're putting these new innovative ways of providing legal services on the same playing field as the way that we have traditionally provided legal services. And that ultimately our responsibility would remain the same, that we are seeking to serve the public as well as ensuring that those that are providing legal services to the public, whether those are individuals or entities, are supported to do so in an effective and responsible way.
So, as a practical matter, these are changes that are happening already. The expansion and sophistication of innovative legal service models is underway. These are technology-driven. They are often services that are delivered via the internet. They are services that may be delivered via non-lawyers. So we have a few options. One is to hunker down and try to use the same regulatory model that's been in place for 125 years. Another is to create carefully controlled conditions to understand how these emerging technologies and these innovations in business model can benefit consumers and can work well with the legal community. The Practice of Law Board and the Washington State Bar Association are both confident that the do-nothing option is bound to be the most risky and most harmful for legal practitioners as well as the public. It would be a bit like an ostrich putting its head in the sand. What we really need to find is the right way to govern a legal services ecosystem that is characterized by effective services for Washingtonians, access to justice, high-quality outcomes, and frankly, that is built on the assets that we see in the technologies that are coming online, these innovations in business model, and the high-quality professionalism that the people who are already involved in our ecosystem demonstrate.
So it sounds like a lot of time and thinking and partnership have gone into this draft order as it stands now. How long have you been looking at such a process?
It's useful to start into this by recognizing that that under GR 25, the Practice of Law Board has as one of its missions, its objectives, the identification of innovative approaches to regulating the practice of law. As part of that mandate, then the Practice of Law Board has been working in this area for many years. Specifically, this became much more concrete as a proposal beginning in 2020, when the first iteration of a blueprint for a regulatory sandbox was developed. The regulatory sandbox then evolved, and that was a document that was published that evolved into a subsequent proposal. Along the way, these proposals had the opportunity to be reviewed by the court. We met as Practice of Law Board with both the court and with the Washington State Bar Association Board of Governors. Through those mechanisms and through the publication of these documents, we've taken in stakeholder feedback. We've had the opportunity to learn more. We've had the opportunity to refine these proposals and to get to where we are today that really is built on a framework document that was published in a law journal just this past spring. And so that forms the foundation for what has been developed now as the draft order. And with that draft order, here we are as with an opportunity for comment, for public input, and we anticipate something that the court will have an opportunity to review and make a decision about in the coming months.
Here we are at the beginning with a decision before the court about whether to run this pilot test and then whether to make any permanent decisions. From your perspectives, can you describe your best case scenario of what might come from this process in 5 or 10 years?
I tend to be pretty optimistic. So certainly my wildest dreams would go in that direction. I hope that this could meaningfully help us to close the access to justice gap, to make sure that all Washingtonians can afford the level of legal services that they need and that they can get high quality legal services. And I also hope that we can face the future with some intentionality. You know, we've all seen different industries that have been significantly impacted by change. You know, I've often heard people joke, when was the last time you used a travel agent? How often do you use a taxi versus rideshare? Those changes have all come about very quickly, and perhaps not with a ton of thought to what the unintended consequences might be, what it means for consumers. Instead, it's really been driven by consumer demand, which is certainly a way to approach it. But sitting where I sit at the Bar Association, which is responsible for regulating the practice of law, I would like to approach it with some intentionality and a lot of thought, and make sure that we have a hand in how this change comes about rather than it just happening to us.
As I look back to my experience 10 years ago, being so frustrated that I was working at one of the world's wealthiest tech companies, and I was able to use technology that we could not make available to the people who most needed it, I anticipate big changes in the coming years. Frankly, we're going to see extraordinary changes in the next 10 years, regardless of any steps in the rules of practice. But our aim with this pilot is to be very intentional and to learn, to make sure we are very carefully thinking about these changes and what they mean for citizens of Washington and for legal services and legal practitioners. Our aim is to use this pilot to gather data that will help us meet our responsibility to regulate the practice of law and innovations in the practice of law in the interest of the citizens of Washington. We want to build an approach to this authorization that expands the availability of legal services, offers those services in ways that are accessible to more people, and ensures that those services are delivered in a way that is safe, ethical, and in line with our rules of professional conduct.